Thank you and good afternoon. I'm Karen Pass. I'm chair of the Venable's education practice, and I want to welcome everyone to our very important webinar on the SBA's PPP loan. Today we're going to discuss how independent schools can support their good faith certification of the need for the PPP loan, as well as how to prepare for possible audit. After recent focus on the industry by the news media as well as social media, we've all seen boards across the country reconsider their acceptance of the loan, as well as those schools who've already accepted the loan look for ways to support their decision. Just so everyone knows, we had over 1,300 participants register for this presentation, and again, as everybody knows, we sent it out Saturday morning, so that's 48 hours, which I think is an indication that this is a topic very important to many. So in an effort to assist our independent schools and our boards navigate this issue, we invited Allison Baker to discuss this question with us. Allison Baker is a partner in Venable. She's the chair of our financial services practice. And Allison just has a wealth of experience in the area of federal audits and investigations. And Allison's been our go-to person at Venable on all things related to the PPP program, but as well as all other federal relief that the government has given. Allison has advised and assisted many businesses that are clients of Venable, but she's also, and we've been so thankful for this, had the ability and the willingness to speak with many of our independent schools on this issue and on all aspects of the PPP loans. So she has been an invaluable resource to the independent school law team as well. So I just want to give a few little pieces of housekeeping. Everyone sees that there's the Q&A at the bottom of your page, and feel free to click on that and make sure to ask any questions that you have throughout the process. The independent school lawyers are going to be monitoring that, and hopefully we'll answer as many questions as possible. And as you heard from the beginning, we're going to be recording this session, and the recording as well as the slides will be posted on Venable's website. So in an effort to give as much time as we can to Allison, thank you so much again for doing this for us and your willingness to join us and support us throughout this process. So I'm going to turn this over to you.
Thank you so much, Karen. Good afternoon. I'm Allison Baker. I'm a partner in Venable's financial services practice, and this afternoon I'm going to spend some time discussing the Paycheck Protection Program, and in particular, a couple of issues that I think are really at the forefront of everyone's mind. Number one, how do I go about making sure that I can execute the good faith certification that's required of me when I take out this loan? And number two, how do I make sure that my school is eligible to receive forgiveness of the loan, ideally all of the loan, and what are the things that we need to be doing to make sure we get those two items correct? So that's what we're really going to be talking about today. And then we're also going to focus a bit on some of the risks around audits and the scrutiny that has been promised associated with taking the loan, and give you all a sense of what you can do to at least prepare yourselves in the event that that scrutiny happens. And then, of course, some of the guidance that we'll provide, we hope, is fairly practical and guidance that will inform your decision making. If we can go to the next slide, please. And actually, we're going to the one after that, which talks about the relief around the PPP, and this is really just an overview of the rescue package that the Congress passed and came into law on March 27th. And so if we go to the next slide, we see what relief does the PPP provide to small businesses. And I'm just going to go very quickly through that because I suspect that most participants in this webinar are fairly familiar with the contours of the program. But in case you're not, essentially the Paycheck Protection Program is designed to incentivize businesses and institutions to maintain payroll during the time of the loan so that they're able to continue business operations and able to continue making payroll for their employees. And so essentially what the loan does is it gives institutions and businesses the opportunity to borrow up to 2.5 times their average monthly payroll for the preceding 12 months from when they take the loan and or the 12 months in 2019. So you can use either of those time periods, either the 12 preceding months from the day you take the loan or 2019, the average monthly payroll during those time periods. You take that 1 month, you multiply it by 2.5, and that's the amount of loan that you're able to borrow, subject to a few other issues, namely that the way that payroll gets calculated is it's salary up to $100,000 for each employee, plus any additional aspects of their compensation, including insurance, et cetera. And then that amount becomes your base for the Paycheck Protection Program loan. The loan proceeds can be used for rent, utilities, interest on mortgage, and interest on existing debt obligations, as well as for payroll. We note, though, that if you then seek forgiveness, there is a discrepancy between what you're allowed to use the loan for and what you're eligible to get forgiveness for. Namely, forgiveness does not allow, does not permit you to receive, you can't receive forgiveness for other debt obligations. So it's payroll costs, rent, utilities, and interest on mortgage. But as I said, you're permitted to use the loan proceeds for a larger number of reasons, namely other debt obligations as well. And I know that there's some school-specific guidance around that as well, and I'll let my colleagues, as we go forward here, Karen and Grace, speak a little bit more about some of that guidance. But basically, as we've discussed, those are the contours of this program. In addition, there's no prepayment penalty, and all payment is deferred for 6 months, including payment on any interest as well as principal. In addition, as you all know, there was a first tranche of debt that was provided by Congress, $349 billion. That money went very quickly in loans, and there's a second tranche of $310 billion that has subsequently been allocated. Much of that money has also been spoken for already. But that's what we're essentially looking at, is $600 and almost $60 billion effort here by Congress to enable small businesses and other institutions to receive this money. And of course, I should also note that the main predicate for being eligible for this loan is that you have 500 or fewer employees, which is not really something that I imagine most of the schools on this phone have as an issue. But obviously, if you're a bigger business, having fewer than 500 employees could disqualify you from being eligible for the loan. If we can go to the next slides, which talk about scrutiny of economic necessity and what does the CARES Act say, and specifically if we can go to slide 6, please. So the CARES Act, essentially, if we can go to the next slide, please. The CARES Act specifically talks about what eligible borrowers are required to make in terms of certifications, and I want to speak specifically about that. If we can just go back one slide to slide 6, which talks about what the CARES Act says. So the CARES Act requires that eligible borrowers make certain certifications concerning economic uncertainty, and specifically the certification, the good faith certification, says that the uncertainty of current economic conditions makes necessary the loan request to support the ongoing operations of the eligible recipient, of the borrower. Now, this is the source, this certification and subsequent guidance in the form of frequently asked question number 31 is the source of a lot of conversation, because the language that I just quoted you is, in fact, language that comes specifically from the CARES Act itself. That is what the statute says. The statute also makes it very clear that there is a waiver of the SBA standard of credit elsewhere test. So historically, an SBA loan was seen as a loan of last resort. The SBA was the place that small businesses went when they couldn't otherwise secure credit because of an exigency. That is not what the PPP is intended to do. It is not a loan of last resort. There is no stated requirement in statute, in any rule, or in any guidance that this be the only source of credit for an institution seeking the loan. And so one of the complications that arises from the frequently asked question number 31, which I'm going to talk about in a moment, and this fact that this is not a loan of last resort, is how do you reconcile those 2 points? How do you make sure that you're executing this in good faith, that the certification around economic uncertainty is one that you're comfortable executing, but also understanding that this is not a loan of last resort, and that you do not have to show that you're burning your business or your institution down to zero to be eligible to receive this loan. I want to talk a little bit about some of what's animating the concern here as well. If we can go to the next slide and specifically talk a bit about what media scrutiny has been around the Paycheck Protection Program. So Paycheck Protection Program comes online at the end of March. The language in the statute says basically any business or institution with 500 or fewer employees is eligible. It's not a loan of last resort. You don't have to show that you can't get credit elsewhere. There aren't a lot of restrictions around it. Or there isn't a lot of prescription around it. It's 6 months of pay interest and principal that aren't paid, that are deferred. There's a component of forgiveness, which functionally seeks to convert all or most of the loan into a grant. The money gets distributed, and as everyone I'm sure on this phone call knows, within a relatively short period of time, especially to publicly traded companies that have obligations, disclosure obligations, it becomes public that certain big companies like Ruth Chris's Steakhouse have taken this loan. Shake Shack, which is not publicly traded but is fairly well capitalized, took this loan. Potbelly Sandwiches took this loan. The LA Lakers take this loan. So some pretty high-profile businesses and operations take this loan. And the media scrutiny ensues. The Wall Street Journal writes an article. The New York Times writes numerous articles. The Washington Post writes articles. Every other paper writes articles. It's all over NPR. And the next thing you know, everybody's asking a question: who should be getting this money? And of course, specific to schools, there's been a number of articles, including one that was fairly well noted in the New York Times, around the fact that certain schools were receiving this money. And as a result of that media scrutiny, you saw what came about, which was this frequently asked question number 31, which was really the administration's response, we suspect, to how this loan was being perceived by the public. Because as I said, the actual strictures of the statute are fairly broad. Basically, fewer than 500 employees, it's not a loan of last resort. There's a good faith certification that I read to you, which is fairly basic. Basically, economic uncertainty necessitates this loan. And this is a time of economic uncertainty. No one on this phone call has ever lived through a pandemic before. The last one we know of was a century ago. So nobody really knows the contours of it, how long it's going to go for, or what that actually means as a practical matter in terms of revenue. And so there is a great deal of economic uncertainty. And so the public and media scrutiny around the taking of this loan really resulted in the administration and the SBA coming out with these guidelines as a way to tamp down on eligible recipients. And I want to advance to the next slide, which talks a little bit about some of the media scrutiny specific to independent schools. There was obviously a well-known article in the New York Times. There was one in the Los Angeles Times, CNN, the LA Times, the Atlantic, the Washington Post. There's been a fair number of articles in fairly well-known publications and media outlets that are read fairly widely, especially among those making policy here in DC, who I suspect felt a fair amount of pressure to make sure that that this wasn't a loan that was taken by recipients for whom it wasn't allegedly intended. And I use the word allegedly because, again, I think there's a disconnect, to be candid, between what the language in the statute says and what some of the media outlets are reporting and the way that some of those stories are being reported on. And so when you conceive of this loan and you conceive of taking it, you really think about it in two ways. You think about the legal risk around executing a certification in good faith, and then you think about the practical reputational risk. And both of those risks, of course, inform the decision, and candidly, sometimes reputational risk in my business drives decision-making as much as legal risk, if not more. And so, we're hopefully able to help you think through some of that today on this webinar. If we can go to the next slide, please. I want to spend a few minutes on the administration's response and just a little bit of a timeline. So on April 21st, Secretary of Treasury Steve Mnuchin raises concerns about which businesses take this loan and whether they were really truly large businesses. A couple days later, as I've noted, the Treasury and the Small Business Administration issue what's become known as FAQ 31, frequently asked question number 31, which basically talks about how any borrower, not just large companies and not just publicly traded companies, but any borrower should be thinking about the good faith certification. It notes that borrowers have to assess their economic need. It notes that notwithstanding some of the language in this FAQ, that again, this is not a loan of last resort. And it also provides for safe harbor. And originally that safe harbor was on May 7th. That safe harbor was subsequently extended to May 14th, so this Thursday. And what that safe harbor, and that safe harbor is subsequently codified in a rule as well. And what that safe harbor basically says is, in light of the guidance that we, the SBA, are giving you, the borrower, about the good faith certification, if you read this and you subsequently determine that you really shouldn't take this money, that you're really not eligible for it, just give it back by May 14th, no harm, no foul. And then on April 28th, the SBA issues guidance in the form of FAQ 37, frequently asked question 37, that essentially applies the same analysis to private businesses as well as publicly traded companies. Although candidly, I don't think FAQ 31 was ever read as applying only to publicly traded companies, but lest there be any ambiguity, the SBA makes it very clear that it intends for the 31 guidance to apply to all businesses, any operation, any institution executing a good faith certification in connection with the loan, which would be everybody. So before you take out this loan, you need to be thinking about these issues. I think it's important to understand some of the political and kind of media background around this, because I think it helps inform not only the legal risk assessment, but of course the reputational risk assessment as well. And if we can advance to the next slide, please. This is the rest of the timeline. So the subsequent part of this timeline, April 28th, Secretary Mnuchin states that any borrower who receives a PPP loan for more than $2 million will be audited. And then on April 29th, the Treasury and SBA issue frequently asked question 39 that reminds borrowers about the certification referenced in FAQ 31. It reminds borrowers that there will be an audit or review of any loan that's in excess of $2 million after the lender submits an application for forgiveness of that loan, or I should say after the borrower submits to the lender an application for forgiveness, and that subsequently there will be additional guidance around how that audit will transpire, and also around forgiveness, the parameters of forgiveness, which I'll talk about in a little while. To date, we have not seen that guidance in the form of additional rules, so we're anxiously waiting for some of that guidance as well. But we certainly can give you some thoughts on how we think, at least sitting here right now, some of those audits, at least some of the issues those audits might look at, and how you can begin to prepare your institution for that if that ends up happening. And then if I can advance to the next slide, please, which talks about Steve Mnuchin's efforts on Twitter.
Allison,
sure, yes.
Just one quick question
please.
before you go on from the safe harbor. So we're seeing a lot of questions about if you return the money under the safe harbor, is it just the amount of money that you received, or do you have to repay, principal and interest, anything else other than just what you received?
So the question is basically, if you return the money, if you return all of the money or some of the money, what do you have to pay? There's no prepayment penalty. So basically, if you take out a loan, and let's say you take out a loan for $2.5 million and you don't want to be audited, so let's say you decide, okay, we're going to return $600,000 of it. There's no prepayment. So in theory, you can return that money. There's no interest that's been incurred that you would be eligible to pay at that time. That's our understanding of it at the moment. Now, again, that might change. And it should be the case that you can simply return that money. I hope that answers the question, Karen.
Great. Thanks, Allison.
Sure. And again, I qualify some of this with, we haven't seen additional guidance on that question of if I return some of the money early. I know there's no prepayment penalty, but is there some amount of interest that I would have to pay? Presumably no. The current understanding of the program is that interest is deferred for 6 months, which means it's paid by the government for 6 months, not that it ultimately comes due at the end. But again, that some of that guidance is still being worked through. And so it's important to kind of stay tuned for that, because it may be that they decide that if you return the money, there is a very small amount of interest that incurs, although I would imagine a 1% interest over a couple of weeks is probably de minimis. But our basic understanding at the moment is there's no prepayment penalty as long as you repay that. And if you pay that before the expiration of 6 months, you shouldn't be paying any interest on it as well. That's our current understanding. The tweet heard around the industry is the next slide. So in particular, Secretary Mnuchin did take aim at independent schools with a fairly loaded tweet that I'm sure many of you saw that was sent on May 1st. It has come to our attention that some private schools with significant endowments have taken PPP loans. They should return them. And then, of course, he references the CARES Act itself and the SBA. And that tweet in and of itself, of course, doesn't necessarily have a force of law, but it does certainly raise the question of how much of this is going to open up independent schools to scrutiny through the audit process. And if you don't return this money and you took this money and you're perceived as having whatever significant endowment number is does that heighten the likelihood if you're getting scrutinized on the back end of this when you seek forgiveness? And candidly, I don't think anyone knows the definite answer to that. Obviously, he sent this tweet understanding the power of his Twitter account and understanding that folks like those on the phone would be paying careful attention. And so our counsel to everybody is to just be very meticulous in how you document your decision-making. To the extent you keep this money or you take this loan, really be meticulous in explaining how you meet all of the different requirements that are spelled out in FAQ 31. And so in that vein, let's go forward and talk a bit about that. If we can advance to the next slide, please. How to assess economic necessity for a PPP loan. And so we talk a bit about this. And what does economic necessity mean? And here are some thoughts that, our team, and I should note that our team is financial services attorneys, it's also corporate attorneys, and this is a collaborative effort. And so we've spent a fair amount of time here at Venable thinking about how any institution, whether it's a for-profit institution or a nonprofit school, can be thinking about its own economic necessity for a PPP loan and how it can be meticulously documenting that need at the board level, so to show that the decision-making was done in the most appropriate of ways. So first of all, you want to assess the totality of the circumstances. You do want to ultimately consider your sources of liquidity, and I'm going to talk a bit about that. Access to other sources of funding. Whether or not there's going to be a need for increased financial aid. So it strikes me that many schools are going to have kind of a double hit. On one hand, you're going to have fewer students who are paying full tuition because of the economic uncertainty and really dire situation in many cases. And on top of that, you're also going to have more students who are seeking financial aid, which could tax your endowments and tax other sources of liquidity that you might otherwise have available. And so you really do want to memorialize those predictive models that you're doing around what you're seeing and what potential revenue declines could do to your school. You may also see an overall reduction in enrollment, which of course could hurt the school, both in terms of obviously tuition dollars that come in, but in other ways as well. And obviously, if you see too much of a reduction in enrollment, that impacts your mission and impacts the overall school's operation. And so you want to be able to explain all of those items and ideas to anybody who may not understand, number one, how schools work, and number two, may be looking and making sure that the decision to take this loan was adequately made and hewed to the good faith certification standards. You probably want to discuss whether or not you expect to lay off employees at the school, whether they're teachers or administrative staff or others, whether you would lay those people off in a but-for world. So if you didn't take the loan, would you lay them off? You probably want to explain a little bit about how, in some cases, your operations have a tail to them. And so you may not see the full impact of the economic situation right now in the next semester. You may see it in the semester after that. You may even see it in the following school year, when a lot of parents who haven't yet committed their finances to tuition are all of a sudden asking a question about what they can and can't afford because they've lost their jobs or they've taken a hit in what they're making each year. And so those are very important parts of any predictive modeling that I imagine your schools have done. And you do want to memorialize that thinking in order to make sure that if somebody comes back and audits you, after you seek forgiveness, you can say, look, these are the analyses that we undertook. This is the predictive modeling we did, looking out at the world, not knowing how long this is going to go for, not knowing the scope of, this pandemic. We did the best we could, looking at best case, worst case, and possible probable cases and what revenue declines would look like. You also want to talk a bit about, and I'm going to talk about this in a little more detail in a minute, but you also want to talk about other sources of liquidity and what that means as a practical matter, because I think it's important for, per the tweet that I just read a few minutes ago from Secretary Mnuchin's Twitter account, just because the school has an endowment doesn't mean that endowment is unrestricted. Much of that money, I suspect, in many cases, maybe all of that money is restricted and has very specific purposes for which it's been earmarked already. So it's important that that issue be addressed, and I encourage schools to address that head on and just put that into your any analysis that you undertake here around the economic necessity. And so I want to talk a bit more about that as we move forward and we give you some practical guidance on how to manage an audit. But before we do that, we're going to go to talk a little bit about preparing for loan forgiveness as well. So if we can advance to slide 14, please.
Allison, before we do that, can I just ask a question?
Sure.
Allison?
Sure, of course.
You know, you talked about what you have to do in order to make sure that you have, you know, good documentation so that you can justify your need for the loan. Can you tell us a little bit about when you're thinking about this and you're thinking about whether you have a need for this loan, do you just think of now, where it seems like you're suggesting that we also think in the future and look at what's going on, you know, next year? Are one of those more important than the other, or how would you evaluate that?
That's a fantastic question, Karen. Thank you. Yeah, so, you know, the loan contemplates, and this is the forgiveness component, it contemplates forgiveness for the first 8 weeks of the loan, and it contemplates being used to make payroll, you know, during the months of May and June, for example. And I think that in many cases and for many kinds of businesses, that is probably, that short-term analysis is probably appropriate. I think for schools where you have you have kind of your costs already spoken for, you know, probably through the end of this school year, if not the end of next school year, what you really need to do is do more of a forecast and say, look, looking out at the world, you know, things, you know, we expect this to impact us, and we expect the impact to be felt maybe after the economy starts to come back to normal, if you will, because the impact is going to have a trail to it. It's going to have a tail to it. There's going to be a longer life cycle for us than there are for other institutions that have, you know, the kind of business where they're basically taking in revenue and spending it. It's different where you're planning from a school year to school year or semester to semester. So I think that distinction is important. And I think the other distinction is, look, you know, just as a practical fiduciary matter, and some of this can go into your analysis, and maybe some of this is just part of your thinking that you don't memorialize. If you're a fiduciary of an institution and the government offers you an opportunity to have, to get a loan that is functionally converted into a grant to make payroll for a couple months, so that inevitably you don't have to tap into other resources to make that payroll, and those other resources instead can be used for financial aid, or they can be used to make other, you know, to pay other operating costs associated with running a school, and you decline to take that money. What does that mean as a fiduciary to the school? And so I think you're right that you do need to be mindful of the fact that the law contemplates an immediate use of the money, but I also think it's important to attach to that immediate use longer term consequences. So if you spend, you know, whatever, $2 million now from your operating budget to make payroll, even if that payroll is already accounted for as a cost, you've already kind of accounted for that cost for this year, that's $2 million next year that you're going to have to take from somewhere else. And I think that, you know, even though money isn't deemed fungible in this loan program, as a practical matter, you know, that analysis needs to be factored in. So we're looking down the road. We see hard times ahead. We have money that if we spend it now on payroll, when those hard times hit us, we may not have that money for those hard times, and ultimately we may have to lay off these very same people. That kind of analysis, I think, needs to be done, and I do think you need to link up the present use of that money with the future potential economic harm that you may not yet fully feel because the impact of it is on a delay. I hope that answers the question, Karen.
It does. Can I just have one more follow-up, Allison? When you talk about predictive modeling, what kind of predictive modeling are you talking about, and how many scenarios do you think schools should really do in order to make sure that they have the documentation that they need?
That's a great question. So when I say predictive modeling, I mean looking out at the next semester or quarters and saying, okay, you know, this could impact us for the next 2 years. It could impact us for the rest of the current school year. It could impact us for the 2021 school year. It could impact us for the 21-22 school year. It could impact us for the 22-23 school year. How do you look out and say, okay, let's say hypothetically we're looking at least the next 2 school years that are impacted, which I think seems very reasonable given the uncertainty of this economic situation, and the numbers get worse each day. And so you say, number one, I'm going to do some modelings, and I'm going to say if we lose 20% of our revenue, this happens. If we lose 15% of our revenue, this happens. In terms of the number of scenarios, I don't think there's a magic number. Obviously, I think you probably need at least 2 or 3 scenarios, but I don't necessarily think you need 15 scenarios. I think you could say, the best outcome is that we only lose 6% of our revenue next year. The worst outcome is we lose 30% of our revenue, and somewhere in the middle is probably where we'll end up. And, do your best to kind of come up with some best case, worst case, and maybe likely middle case scenario. And it strikes me that, at least 2 or 3 models is probably the minimum number of models that I would imagine you'd want to do as a business practice. But I don't think there's some magic number that you have to hit in terms of number of models, nor do I think there's some magic timeline that you need to hit. It strikes me that if you're a school, it's probably at least a 2-year modeling that you're doing, if not 3, given the way, families make decisions about tuition, given the way you make decisions about admissions and financial aid. And I think each school probably has a formula that it uses. And, I would encourage you to hew to that formula, but just be a little more predictive when you do so. I hope that answers the question.
That's great. Thanks, Allison.
Sure. So I want to talk briefly about forgiveness because I think it's part of this, and it's some of what we expect, schools to be asking about. And I want to qualify what I'm going to say with the following, which is that we haven't yet received the full guidance that the SBA is promising us about forgiveness. But I think we know enough to give you some good guidance on, what you should be doing to document and how you should be thinking about it. You again can use the proceeds from the loan for payroll. There's other proceeds. You can use the proceeds also for interest payments and debt obligations, namely rent and utilities and mortgage obligations. I understand, though, that there's some guidance around doing that or not doing that, and I defer to Karen and Grace on that, except to say that for the most part, as I understand it, schools should really be using this money and seeking forgiveness around the use of this money for the making of payroll only. And Karen, I don't know if you want to speak briefly about the fact that PPP
Sure.
funds constitute federal financial assistance.
Sure. So as we know, and we've all talked about this, I think when we take federal funds, there's other requirements that come along with federal funds, which is why in the past we've always advised against taking federal funds. And the federal funds triggers the requirement to comply with certain non-discrimination laws, and we've talked about those: Title IX, Title VI, the Age Act, as well as Section 504. There's question about whether or not, if you use these funds for the payment of utilities or the other things that you can use it for, then it may attach to the building. So, for example, if you use it for rent and utilities, then the building that you use it for rent and utilities, to support, then as long as you have that building, you will be required to comply with the federal laws. Now, we haven't been able to confirm that absolutely, but there are other indicators that would be the case. And what our concern is that since we don't have absolute certainty one way or the other, in an abundance of caution, we're strongly advising that you not use those resources or use the funds for those resources. Again, we're going to comply with these federal non-discrimination laws, and the benefit to us is that it's only for as long as you owe the money. So as soon as you pay it off or it's forgiven, you're no longer required to comply with the funds. With the federal laws about non-discrimination. So to the extent that we can limit that and not risk it, that's why our recommendation is as such.
Thank you. In addition, when you're computing the amount of eligible loan proceeds that are eligible for forgiveness, and you're looking at payroll, it's the same thing on the back end for forgiveness as it was on the front end when you were looking at eligibility, which is that it's no salary. To the extent any salary exceeds $100,000, you stop counting at that number, but you can still consider other aspects of compensation for those employees when you go and you compute the amount for which you can seek forgiveness. I want to advance to the next slide if we can. So specifically loan forgiveness, as I think I noted, this whole loan program is really designed to incentivize institutions and businesses to maintain payroll and to not be forced to furlough or lay off people. And again, for forgiveness, you can use really payroll costs are the key component here for schools, at least for forgiveness. There's language in one of the interim rules that says that you have to use at least 75% of your loan proceeds to make payroll, and that if you don't hit at least that threshold, then you won't be eligible for forgiveness. The way that that works and the mechanics of how that works, candidly, are still being worked through by the SBA. We haven't yet received final guidance on all of that. And indeed, just this weekend, the Inspector General of the SBA came out and issued a report that said that the 75% number was somewhat at odds with the statute itself. So stay tuned for how that works. But as a base level, our understanding, at least currently, is that in order to receive the loan, in order to receive loan forgiveness, you have to at least have used at least 75% of the proceeds for payroll. Whether that's 75% of the amount that you get forgiven or it's 75% of the total loan is a debate that's still being had. We have been advising people that it's the former, but we're waiting to get guidance from the SBA around this issue, so please stay tuned for that. But I want to talk a bit about what can reduce your total amount of loan forgiveness and some of the benefits around rehiring. I'm just going to speak very briefly about that. So if we could advance to the next slide, please. Reductions to loan forgiveness. At a high level, as I said, this is designed to incentivize maintaining payroll. So to the extent you have fewer employees during the first 8 weeks of the loan as measured against one of two time frames, either February 15, 2019 to June 30th, 2019, or between January 1, 2020 and February 29, 2020. So either of those dates, you can choose which one. It's basically comparing your total number of average monthly full-time employees during the first 8 weeks of the loan against the total number of average full-time employees during one of those time periods, so either February to June of last year or January to February of this year. And to the extent there's a difference between those numbers, and that difference is because you laid off people between February 15th and April 26th of this year, if you rehire those laid off people, and presuming they were laid off during that time frame of February to April of this year, you can have those people counted toward your total loan forgiveness. So the idea is basically if you had to lay off people because of the pandemic, you can rehire those people, no harm, no foul. That amount will still get forgiven when we compute your payroll amount that's eligible for forgiveness. That's what the SBA is basically saying. Similarly, as to employees who are making less than $100,000 or starting to count at $100,000, if there's a greater than 25% reduction in pay for those employees during the first 8 weeks of the loan as compared against Q1 of this year, as long as you make up for that reduction in pay, that too won't get counted against you for forgiveness. Now, the practical matter, I suspect that for most of the schools listening, this rehiring and reduction in payroll is probably not going to be applicable because of the nature of how your school operates in the school year. It seems unlikely that many, if any, institutions, laid somebody off in March, given that most school years end in May or June. But I present this as well as information in the off chance that it does affect at least one or two listeners on this call. And if we can just, so the slide after this one talks about the benefits of rehiring, which is what I just discussed. And then the slide after this one, which talks about repairing reductions in payroll, I wanted to just briefly touch on that. And if we can go to the next slide, which is slide 19, which talks about preparing for audits today and tomorrow. And I want to talk a bit about this in more detail. And this is some analysis, as I said earlier, that comes from both our financial services practice at Venable, but also our corporate practice as a matter of corporate governance, which I think is relevant to everyone on this call, because as you go through and you think about the kind of modeling that you need to do, per Karen's question earlier, and the way you think about forecasting and how many semesters or school years you go out, how many different types of models or scenarios you need to have. All of that is very important here for making decisions around whether or not you should be, how you go about executing the certification in good faith. So again, you definitely want to make sure that you've modeled at least 2 or 3 different scenarios, that those models account for revenue declines over probably at least a 1, 2, 3 year period. I don't want to be too prescriptive in our advice, but it strikes me that you would probably want to do it for at least 2 or 3 years. You need to address other sources of capital or access to liquidity. And the specific language in the FAQ says, and I'm just going to read it, it says, borrowers must make this certification in good faith, taking into account their current business activity and their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that is not significantly detrimental to the business. So what that basically means is you need to take stock of other sources of liquidity that the school has access to. So is that an endowment? Is that a revolving line of credit? If it's an endowment, why can't you access that endowment now for purposes of, making payroll? And the answer is probably that most of that endowment or much of that endowment is restricted, and or it's earmarked already. If it's not restricted per bylaws, it's nevertheless assumed to be earmarked for certain designated costs that could arise in the future or that are likely to arise now, or maybe something that you're thinking about now, such as requests for financial aid in the fall. I'm sure you're already starting to get those requests, and it may be that you have an endowment that is either contemplated for being used for those purposes, either because it's specifically designated that way and restricted, and or it's earmarked in some other form. But the point is that you have an endowment, and that endowment you would need to explain, and I would memorialize this, why that endowment alone isn't an adequate source of liquidity here, why that endowment doesn't allow you to, would not allow you to continue to operate as a school without causing significant harm to your operations. The other likely source of liquidity for schools is a revolving line of credit. And similarly, same thing, either a revolving line of credit that you've already drawn down, that's earmarked for other purposes. Some revolving lines of credit have covenants in them that are fairly strict about how they're used or other requirements around their use. And so you really would need to memorialize that as well if you have a revolving line of credit, why that revolving line of credit is not an adequate source of liquidity here and why it necessitates you taking this loan. And candidly, if it is an adequate source of liquidity, then you need to explain why it's not enough and why it doesn't get you where you need to go potentially. Another possible source of liquidity could be cash reserves, which I think some schools have. And to the extent you have cash reserves, which are not part of your endowment, and they're not part of your, they're not your obviously revolving line of credit, you'd have to explain why those cash reserves similarly aren't adequate here and don't get you there. So those are very important conversations that you need to have, and you should be memorializing those discussions. You should be making them part of any decision making that goes into the board's decision at your school to take this money. And I want to say something. The safe harbor is Thursday, and so to the extent you've taken this money and you've already made a decision to take this money, I recommend memorializing your predictive models, your predictions around revenue, the impact that revenue can have on your operations if there's a substantial decline in that revenue. I should say the impact the decline in revenue would have on your operations, and why other potential sources of liquidity, so endowments, cash reserves, revolving lines of credit, why those other sources of liquidity are not adequate to get you where you need to go based on your predictions. And I would memorialize all of those different streams of thought and make sure that they inform a decision that your board has made about the need to take this money. And if you made that decision after the FAQ 31 came out, great, and you've already done all of this, great. If you took the money and you made a decision based on the good faith certification, but in the time frame from when you made that decision, the FAQ 31 came out, the safe harbor came out, I would encourage you to memorialize those items again and to recommit your board to this decision before Thursday, which is the safe harbor day, and to memorialize your recommitment of that decision so that you're able to adequately address any conversation or question that you get in the off chance you do get a question during an audit or subsequent scrutiny. And you can say, look, we made a decision in good faith that was based on all of these different factors. We subsequently went back, we memorialized a lot of our analysis and our thinking, and we recommitted to that decision in light of the guidance that the SBA provided, understanding that there was a safe harbor at play. And that is a perfectly fine thing to do. You should memorialize those communications. You should memorialize that conversation that you're having with your board or whomever your decision makers are, a subset of your board, your executive committee, just to make sure that on the off chance you're audited, you have those documents and they reflect real-time decisions that were made and real-time discussions. And then we have some other practical guidance here, if I can advance to preparing for the audit tomorrow. Again, same kind of advice. You want to have a clean file with your calculations. You want to have all of your materials that inform the decision. something I didn't get a chance to talk about earlier, which is the segregation of loan proceeds. So when you get your loan, what you ideally want to do is you want to segregate that money either in a separate operating account or in a way that you can meaningfully show that all of the proceeds from that loan were used only for payroll purposes. And you can specifically, in a very clean, delineated way, prove that to a bank when you go and you make your loan application. The idea is, the forgiveness application rather, the idea is in the back end of your loan, so after 8 weeks have transpired, you would make a forgiveness application with your bank. Your bank then has 60 days to consider that application in tandem with the SBA, consultation with the SBA, and then at some point during those 60 days, some audits could be conducted. That seems to be what's contemplated. I say that because we haven't gotten formal guidance on it, but that's our understanding based on what we've heard and what we've read so far, is that the audits would be conducted during the time frame when forgiveness is being considered. So you want to have all of this documentation in place, and you also want to segregate the loan proceeds that you receive. You don't want to commingle them with other operating monies, just so you have a very clean way of showing we got this much money and we used this much money on payroll. And here are payroll logs that show it, ADP payroll logs or whomever your payroll service provider is. And we have all of this evidence and all of this proof. And again, you know, we also recommend that you track your expenses, you follow any other direction that your bank is giving you or your lender is giving you. You assemble the documents around the expenditure, such as payroll records, and that you also have some guidance here that you prepare that as a backup package so that you have two. You have like a real-time package, and then you have basically, you know, a way of showing that this is the decision making around the good faith certification, the economic uncertainty, the necessity of the loan. These are our predictive models. This is what happens if we lose revenue, you know, as predicted. This is why our other sources of liquidity are not adequate. They don't get us there. We took this loan. We used this loan only for payroll. We segregated those monies. They were not commingled. And we have the payroll logs to prove that all of the money we received, or 75% of it, the rest, you know, you're either going to give back or not use for other purposes per Karen's discussion, that we can prove that we use this money for payroll, and here is all of our evidence. And I think that that is the best practice to go with. I want to just give a few clarifying thoughts here around the audit process, and then I'm going to stop and we can take questions, because I suspect there's a lot of them that have accumulated over the last 50 minutes or so. We don't know all the contours of the audit process, but we expect that the audits will be conducted by the SBA. We expect, again, that they'll be looking at, you know, eligibility determinations on the front end, which I think for all schools is not going to be an issue. The good faith certification and all of the documentation I've described, the way you've used your loan proceeds, and how and why you think you're eligible for forgiveness. There are some discrete instances where we expect audits could give rise to investigations. Candidly, I don't think that that's going to be the majority or even close to the majority of schools or anyone else that gets audited, but there probably will be a handful that result in investigations. Sometimes audits are sources of fact-finding that can give rise to, as I said, an investigation which results in a subpoena. We're giving you this advice because it's important to kind of understand the full scope of possible consequences. You know, sitting here right now, it's hard to predict how likely that is. It doesn't seem super likely, given the difficulties around proving that a school didn't act in good faith or an institution didn't act in good faith when it took the loan, especially if you're able to document your thinking and all of the other sources of liquidity that you have that are not adequate. But of course, we have to, you know, we want to give everyone the full scope of kind of what's going on in the world. If we can advance to a couple of other slides, the next one, which is slide number 23, which talks a bit about potential theories of liability. So if we can go to slide 23. And so a couple of potential theories of liability. The False Claims Act, which basically involves basically having to make a showing by the government that an institution knowingly made a false record or engaged knowingly in a false claim or engaged in those things with reckless disregard. That's a pretty high standard. And my guess is it's going to be awfully hard to show that for the overwhelming number of institutions and companies that take this loan, assuming that an audit even gives rise to any subsequent action. There's also a little known statute called FIREA, which in my world as a financial services lawyer is actually more well known, but in general isn't that well known. It's Financial Institutions Reform, Recovery, and Enforcement Act of 1989, and it basically precludes individuals or businesses from making false statements to banks and engaging in false, basically knowingly making a false statement or a false representation to a bank. And if you do that, then there's certain civil penalties that the Department of Justice can bring. We mention these because we would be remiss if we didn't. Again, there's no high expectation here that any of these audits or most of these audits or more than a very small number of these audits are going to yield any of these theories of liability. Finally, some of you may have heard about, if I can just go to the last slide or the next slide, which is slide 24, some of you may have heard about a Department of Justice criminal action that just came down from Rhode Island. And in that case, and that was on May 5th, so that was last week, the U.S. Attorney's Office in Rhode Island essentially prosecuted two people who basically made up a business and fabricated all of the underlying documentation to fraudulently get the loan, the PPP loan. That's a pretty extreme example of fraud and falsehoods, and suffice to say, it's criminal fraud. It's a pretty straightforward case of it, if you believe the allegations. And so that's an example of kind of what's going on in the world right now. And I give that as an example because that seems to me like a pretty straightforward case of this is something nobody should ever do, which is make up documentation to secure a loan for which they wouldn't otherwise be eligible. And obviously that's pretty far afield from what we suspect anyone on this call is thinking about. I think the issues here go more to how do we make sure we execute our good faith certification in good faith and we get comfortable with that risk to the extent there is risk. And again, how do we make sure that we're eligible for a maximum amount of forgiveness? And so with that, I'm going to turn this over to questions because I suspect we have quite a few of them. I know that go ahead, please.
So there's a couple great questions, or a lot of great questions, and I know that, it shows why this is such a hot topic. So you talked a lot about sort of setting up a process and documenting clearly and carefully how the school came to its decision that they had good faith certification to request this loan. And can you talk to us a little bit, Allison, about board minutes and about board resolutions and what you would like to see in board minutes and board resolutions that we would make as part of this package?
Yeah, absolutely. So, without you deviating too far from what you normally do in terms of your board minutes and board resolutions, everyone has their own manner in documenting that. What we would want to see is that there is some specific decision-making around the loan and the good faith certification. So your decision makers, whether that's your board, your executive committee, looked at the predictive models. They looked at potential declines in revenue over a number of different scenarios, over a number of different years. They discussed what that could mean for the school's operation. They discussed potential sources of liquidity, a revolving line of credit, cash reserves, and endowment. And they made a determination that those other sources of liquidity were not adequate given these predictions. That conversation, a memorialization of those decisions are something that, I think should be part of board minutes or some other format in which you document your formal decision-making as an institution, whether that's, in most cases, it probably is board minutes, but something to that effect, Karen.
Great. So let me ask another one then, Allison. We've gotten a lot of calls and a lot of questions about this. So, our teachers around the country have been working so harder than ever before because they're doing distance learning and they, it really requires a lot of time and energy from them. And a lot of our schools would love to give a stipend to these employees to show that they really appreciate all that they've been doing. Would that be something that we could do and then ask for forgiveness, submit with our forgiveness request?
Yeah, that's a fantastic question. I hope everyone could hear me. I know we've gotten some feedback that it looks like sound went out. I hope it's back at 258. I saw 257. It sounded like it wasn't, but I can hear you, Karen. So, there isn't formal guidance around whether or not you can give bonuses as part of payroll. what I would say is this. In some instances, we've been asked this question for different kinds of businesses that have hazard pay issues, where they have employees who are kind of on site, doing things that could expose them, for example, to COVID. And in those cases, we've said if you have some background or basis to give hazard pay and you can document it, then you can probably do that. In terms of retention bonuses for teachers or for other employees, I think it depends really on your institution's history. And whether or not that's something you've done in the past for different reasons. There isn't any guidance around it. So I really do think it comes down to, can you make a good faith argument that this was something you did in the ordinary course, either because of the, extenuating circumstances around distance learning or concerns that, some people in your faculty maybe have done extraordinary things and you kind of want to give them an appreciation bonus. If you do that, and I'm not telling you can or you can't, because again, there just isn't clear guidance on it. I do think you want to document it and be very meticulous about how you explain why you're doing that. All the better if it's something you've done historically, even if it isn't something you do every year. Let's say you're in New York City, and during Hurricane Sandy, you had teachers who came into school and did extraordinary things, and you gave them some kind of retention bonus. Even if it wasn't really hazard pay, something where you've had an exigency in the past and you've in some way compensated employees or recognized them through money. That kind of history would probably be helpful in justifying any decision here to do that. But unfortunately, Karen, there isn't any real clear-cut guidance around this issue.
So let me ask this last one to wrap up, because this is the one I think in the industry we're all suffering so greatly. And it's a question of significantly detrimental. So, the concern that most of our schools are having is because of all the media we've seen about our endowments and other forms of liquidity. Any guidance you can give us on what is considered significantly detrimental to the school?
Yeah, so I think a few things. And again, this is just kind of reading the tea leaves, but not really having any formal guidance from the government. It strikes me that if you have a mission, which all schools do, and your operations were going to be impacted in a way that caused you to alter the course of your mission or harmed the school's mission. Let me give a very concrete example. If you ultimately have to dig into your endowment that is, has designated monies for financial aid, and one of your missions is to have, economic diversity at your school to educate a cross-section of the population, but you can't do that the way you want because you have monies that have been diverted to other things here in lieu of taking the PPP. That would be an example of something that could cause detrimental harm to the business, the operations of the school. If you have to, get rid of 4 math and reading specialists, and that precludes you from offering that kind of one-on-one training or teaching that you promise students and their parents, that would be an example of something that could cause detrimental harm to the school, reputational harm and actual real practical harm. Those are the kinds of things I'm thinking about. And obviously that's going to vary school by school. But anything that kind of really significantly causes the school's operations to be impacted in a way that either deviates from its mission or hampers its ability to offer the kind of same consistent education model that it's been doing, would strike me as examples of something that could be significantly detrimental to the business.
Alice, that's great. Thank you so much. So we are at the end of our hour, and I want to be respectful of everybody's time, and especially yours, Allison, because I know how busy you've been. I want to thank everybody for joining us for the call today. We have a lot of questions, and we will try our best to answer some of these. We are also going to be posting this online on our website, and it seems like there were some people that went in and out and could hear and couldn't hear, so please feel free to go back on our website, listen to the recording, and also the slides will be posted on the website as well. So thank you, everybody, for joining us, and we wish everybody good luck. Bye now.
Thank you. Bye.